Welcome to Michigan Reimagined, presented by T.A. Forsberg and Wagoner Financial. And here's your host, Chris Buck.
So we discuss entrepreneurship and small business development regularly on this show, but one area I've never covered is intellectual property. Innovators need to protect their inventions and processes, and here to share how that all works is a senior attorney from Foster, Swift, Collins & Smith, PC, Mr. Mikhail Murshak. Welcome to the show, Mike.
Hi, Chris. Thanks for having me.
We've had you on again as guests as a board member of some nonprofits here in town, but never really talked about you specifically and the things that you do for our community. So I'm really anxious to hear about your story and have you share with our listeners who I think would really benefit from this particular conversation.
Yeah, I'm happy to be here. It's a pleasure to talk with you again and be in this room.
Right on. So start by telling us how you got involved in practicing law, because I don't think your undergraduate degree was legal. I mean, it was legal to have and obtain, but it wasn't regarding law. And then how did you actually find the niche of intellectual property?
Yeah, so it's the common path to law school is typically like, oh, I majored in history or political science, or maybe even English, and then I decided to go to law school because it was trickier to find a job, and maybe I was interested in law for various reasons, whether I wanted to, save the world, and then they got into law school and met the green-eyed monster, which means they're looking for the competitive jobs with the high-paid salaries and more of the corporate law universe. But my path was a little bit different because I majored in chemical engineering, which was something that stemmed from my family being technical people. I mean, I have a mother with a PhD. My dad had his chemical engineering degree. And so my older sister went to chemical engineering. Her husband was that. So I was aggressively pushed in that direction. Plus, I had aptitude. I was good at science and math. And I went to Hazlitt, local school.
Yep.
And they had an incredible science program, lots of AP classes and math classes. And so heading into Michigan State, I was chemical engineering. And then my resistance against that, because of my extroverted nature, I said, maybe I want to go to law school. And junior year, I started studying for the LSAT and got into law school and found myself moving to Connecticut to go to University of Connecticut Law School. That's the team everyone thinks about as the basketball program.
Yep.
We used to have a T-shirt that said, a law school the women's basketball team can be proud of. And
okay.
And so the second I got into law school, I started seeing information about if you have a science degree, you should think about patent law. You should think about intellectual property, which turned into first internship, second internship, and so on. So I've really only practiced intellectual property law my entire career. And just like almost every area of law, nothing fits neatly into a specific silo. Everything kind of blends with other areas. So I was in-house for 3 years for they were a startup at one point, but then they became a big time player in the sleep technology industry, right? They make beds and mattresses and adjustable beds. And when I was in-house there, I did everything from business law, contracts, negotiations, and so on. So, but also managed our intellectual property portfolio. And intellectual property, or IP, usually refers as an umbrella term for 4 areas of intangible assets.
Okay.
So trademarks is one area, and that has to do with branding. Patents is a different area, and that has to do with inventions. And copyright is a third area, which has to do with works of authorship, whether you write a book or paint a picture or record a podcast or perform a play, et cetera. That's copyright, and everyone has some sort of affiliation with that. We all go to movies, we all read books, et cetera. We all like art, I think.
Yes.
And then there's trade secrets, which basically is what are the various mechanisms you can use to maintain things that are proprietary to your business and that would be harmful to you and offer a competitive advantage if your competitors had that information. So things like customer lists or business strategies or even marketing strategies, perhaps manufacturing techniques and so on that are kept in closed doors, et cetera. So that kind of falls under the umbrella of trade secrets.
Makes a lot of sense. Okay. I was wondering where the fourth one was. I knew copyrights, patents, and trademarks. Then you mentioned 4, so I was waiting for you to get there, but that makes a lot of sense. So, and I'm glad you talked about being the in-house attorney for a corporation because you said it was a startup, but then grew into a big company. When I think of intellectual property law, I think of startups, and the professor who has an invention and you need to help them legally, protect their invention as they begin a startup company. But in a private conversation, you shared with me that major corporations constantly have needs for legal protection for inventions that they're making, even at companies like IBM or Ford or whoever, right?
Yeah, sure. So patents, which are specific for inventions, and you have to proactively pursue a patent to have any rights to it. And if you think of intellectual property, you focus on the word property. That everyone can think of real property. You own your house and your deed, and you think of personal property like the jacket you're wearing or your watch or anything of value, and you get to own that. And the real right you have to those physical properties, those real property, is that you get to exclude others from using it. And from a patent standpoint, if you invent something and you're able to obtain a patent, then you have an intangible asset, but it's not something you can hold in your hand. I mean, sometimes you can hold the invention that's made, but really it's the idea and the claims, the legal language surrounding the ownership of that invention. And that patent allows you to exclude others from using it for a fixed period of time. So the reason I say this is, in the end, early on in my career, it became very clear that for the most part, patents is a game among kings and giants. So when you look up case law, famous case law that occurs at the Supreme Court and otherwise, it's Apple versus Samsung, two giant billion-dollar companies. I think maybe one of them or both of them are trillion-dollar level valuations now, et cetera. And these companies, because they spend so much money on developing products to be used by the consumers, spend a lot of money protecting themselves. Now, there's a couple that can mean lots of different things, because people think protection might mean like a shield. Really what it does is it gives them the assets to be able to assert their rights to exclude others from using it. So when Apple owns a patent on a specific feature of the phone or multiple features of the phone, they can tell Samsung, you can't use that without either paying us, or we need to have you stop entirely. This specific invention gives us an advantage. Now, they spend a lot of money on scientists. They spend a lot of money on technical people with technical backgrounds and knowledge and experience, and they come up with new ideas, new inventions and features, and they sell to consumers, and that gives them one advantage in the market. And meanwhile, their major competitors are doing the same thing. So all of our phones over the last 15 years have advanced in both speed, accuracy, battery life, photography, right? Now, everybody, I always joke when I see people with a real camera, I'm like, that's an interesting phone. I've never seen one like that.
Yeah, I heard a statistic that more pictures were taken in like the last 2 days than in the history of film.
Oh, that's incredible.
Up until like the year 2000.
Yeah, it becomes that it creates these coattail effects, right?
Right.
So now how do we manage our photos, right? Like if we look at our phones and I have 22,000 photos and videos and I'm running out of battery space, storage space, Apple sends me an alert and says, hey, do you want to spend $5 a month and we'll just throw it up in the cloud and give you extra space? So just imagine all these new businesses and products that can exist. So that's the coattail effects of a disruptive type of technology like a smartphone. You think of the automotive industry, right? It's not General Motors trying to attack the individual guy in the garage who just came up with a new a new fuel injector, let's say. But they're developing really cool new technology. You're seeing a lot of the EV models coming out into the market now. And Ford and Chrysler and Toyota and Honda and all the other automotive companies are all competing in the same way. And once they build their patent portfolios, they can work as a defensive tactic, like a Cold War. Like, okay, you have your patents, we have our patents. We'll just agree not to sue each other, and we'll stay back, and everybody can run their own show. And sometimes it's perceived ownership. So if you have the most patents or are the largest patent filer, like in the state of Michigan, I believe it's General Motors, but I can't be positive. It might be Ford. And that gives them the license to say, hey, we're the biggest innovators in the automotive space.
Fascinating. Well, all this is about protection, and I want to thank some friends over at Wagner Financial. Are you ready to make smart financial decisions? Wagner Financial offers a proven process for financial transformation, empowering individuals at all stages, whether you're just starting out, nearing retirement, or anywhere in between. Stop feeling unsure about your financial path. Wagner Financial can help you undergo this financial transformation. Schedule a consultation today to discuss your individual needs and discover how Wagner Financial can guide you by visiting wagner-financial.com or give them a call at 517-853-3367. So when I look at a product, I'll often see patent pending. It's a simple, stupid question, but I guess what does that mean? It seems like every patent is pending. So what's the process of patenting, an invention?
So if you invent something, the simplest answer is you have to apply for a patent. So you have to prepare a patent application and comply with all the legal rules and regulations that patent lawyers are sophisticated and, by the way, licensed to do. In order to be a licensed patent attorney, you have to have some sort of technical background, which goes back to my chemical engineering degree. Once I have the engineering degree, I qualify to just sit for the patent bar exam. And then that's a separate bar exam, separate from a state bar exam. Yeah.
Huh.
So I'm licensed in the state of Michigan. I'm also licensed patent attorney with the U.S. Patent and Trademark Office. And that's only federal. There's no such thing as a state patent. It's all federal law, but it's specific to each country. So there also are treatises among foreign nations. The process is you apply for a patent, you submit a patent application, and depending on the technology area, it might take a year and a half. Right now, the average is about 15 months before the patent office gets back to you and they examine your application. But sometimes it can take 2 or 3 years. And then there's a back and forth between the applicant or the applicant's lawyers, patent lawyers, and the patent office. So that process can take time. And so on average, it can take 2.5 to 3.5 years to obtain an actual issued patent. That whole entire time, from the moment you hit submit and file your application, you have patent pending. As long as your application is active at the patent office, it's pending. When it actually issues as a patent, a lot of times what you'll see is it's the language on that particular product or the packaging or even on their website might switch to say, we have 4 patents on this, or my patented blah, blah, blah widget, et cetera.
Right. Okay. And does that give protection from the time that is it kind of time stamped when you submit your application, that if 5 months later someone has stolen your stuff, but you make it successfully through and now you have a patent?
I'll give you the most famous answer in legal history, which is that it depends.
Okay.
So patent pending gives you, to some extent, perceived ownership.
Okay.
And it's as a competitor, if I want to start, if I say, let's say you invented a new widget and I'm a competitor and I say, that looks great, I'm going to start selling that. Now, I have every right in the United States to compete with you. Right. If you start a lemonade stand, I can start a lemonade stand. And I use this example all the time when I talk to my students in law school. I teach at Michigan State as an adjunct for trademark law and IP practice. So if that widget is unprotected, I can be like, great, I'm going to start selling that widget. And now we compete in the market, and that's totally legal. And I have a right to compete.
Even if it's my widget.
What does it mean to be your widget?
Right.
Right. I mean, like I said, Coca-Cola came out with a drink, a cola carbonated beverage. They called it Coca-Cola. Pepsi-Cola started selling theirs. It doesn't matter who had the original idea. Everyone has the right to sell cola in the market. Now, the assumption is that you can compete. You have a right to compete, right? There's a presumption that you have a right to compete unless what you're doing is unfair. And the unfair competition is where trademark law kind of evolves. So one form of unfair competition is deceptive practices, right? Drink my Pepsi Cola and you'll live to 105. Okay. That's an example, just a random example of deceptive practice. Another form is misappropriation. So you steal content or information or whatever from your competitor. That's a form of unfair competition. And now you're liable, right? There's a liability there for the bad actor. And another form is trademark infringement. And so if I'm doing something where the public would be confused as to the source of that good, so in our example, cola, Pepsi Cola was running things using the red or the cursive where it looks like this product was actually coming from the Coca-Cola company, that would be trademark infringement. Patents, on the other hand, while it's patent pending, and when getting back to your original question.
Yeah.
So there's a perceived ownership that you're claiming something when you say patent pending. I don't own this yet, but I applied for a patent for it. And once that issues, if you've been practicing my invention this whole time, then once that issues, you're going to be liable for infringement, and you're potentially liable for willful infringement, which comes with a higher tax or a higher penalty or cost to the infringing party. So again, you invented a widget and you applied for a patent, and now it's on the market and it says patent pending. And I say, well, whatever, I'm just going to sell it anyway. We'll see if he gets a patent on it or not. And then you do get a patent. Now I'm in big trouble.
In arrears, though, it's not now that the patent is issued, I have to stop and I'll be okay, or would I be in trouble for this?
It could go. I think it could go. It depends either way. But most of the time, you're not stopping. And by the way, it's not easy for Chris Buck LLC or Chris Buck Inc. to start a widget company, make the manufacturing, come up with packaging, find sales channels and shelves to put it on. Like Home Depot doesn't have like an open policy. Those shelves are all full and they know what's going on them. Right. So it's not an easy process to do that. Now, if I start copying you and start selling all over, I have to go through some of those same exact steps. And I may be an existing company that has a sales channel, but I still have to manufacture, buy materials, put together packaging. And so to just stop all of a sudden seems like a mistake. So what long story short, long story long, I guess, is that once you have patent pending, as a competitor, if I want to do that, if I want to sell your product and it says patent pending, I have to, at some level, evaluate my risk tolerance for that. So is the patent published? No. Okay, well, I got to wait till it publishes. Patents don't publish until the 1.5 year mark from the date they file. I may have to have an attorney review it. So now I'm already, as your competitor, on my heels and having forced indirectly to deal with your patent pending status and spend my money, resources, and time, and potentially legal time to figure out whether I can go forward or not. So sometimes it's a sit and wait game. Sometimes it's, hey, the patent published and this is garbage. This is a terrible patent. They're not going to get anything issued and I don't care. But sometimes it's, oh, this looks pretty strong. So we have to kind of sit and wait, or we got to reach out to that company and see if they're open to a licensing agreement.
Got it. Okay. So let's spin over to you're with Foster Swift. Talk about them as a firm. What kind of footprint do they have, and what do they tend to specialize in, or do they handle clients from all walks of life?
Yeah, I mean, Foster Swift, I'd love to talk about that. They are a very highly reputable firm based originally from Lansing, Michigan, so just down the road. They've been around for a very long time, and now we have offices in Grand Rapids and a significant critical mass in Grand Rapids that services the west side of the state, plus clients with their businesses outside the state. And we have a Southfield office that essentially represents Detroit, the greater Detroit area, and other parts of the state of Michigan, as well as corporations that have activity all over the country. So with, I think, over 100 lawyers now, and we're growing. We just added some first-year associates that we're excited to have on board, and the firm is doing really well. And we, I think, handle every area of the law that you can think of. If not, we're part of a group where we can find lawyers for you. Like, for example, if a client's uncle needs an estate planning person or probate litigator in Florida, we can reach out and find somebody to help handle that kind of stuff. I'm the intellectual property attorney for the firm that handles patents, trademarks, and then copyrights. I have an associate named Lindsay Mead that helps out a lot with the trademark and the copyright stuff. And what's great is that I get involved in other areas of practice. So our corporate business lawyers that are helping with closing of big multi-million-dollar deals where one company's buying another, and we have to do the IP due diligence. Got to review their trademark portfolio and their patent portfolios, make sure that there's a clean chain of title in terms of who owns it and what make sure we have an idea of when things are due, when fees are due, when renewals are due, et cetera. So that's really fun and exciting for me because I'm not just coming into work and dealing with the same, there's 10 other guys that are just like me. It's all different types of work. Right. And Foster Swift is intimately involved with the entrepreneur and startup community all over the state, but especially in Lansing. And we work closely with MSU Research Foundation and a lot of the spinoffs and startups that are coming out of that area of town.
Makes a lot of sense. And to that end, I'll give a nod to our friends at Michigan State Research Foundation and their Michigan Rise program. This episode is brought to you by the Michigan Rise Pre-Seed Fund, providing early stage funding to Michigan-based startups. Since 2020, Michigan Rise has helped high-tech, high-growth startup companies achieve commercial and technical milestones through capital formation strategies, talent development, and customer acquisition tactics. With financing options for every stage of the entrepreneurial journey, Michigan Rise significantly increases the impact of new ideas and research. Visit www.michiganrise.com to discover how the Michigan Rise can help fuel your startup's growth. Michigan Rise is supported by the Michigan State University Research Foundation and the Michigan Economic Development Corporation. So, it seems like I said at the earlier part of the show, that finding inventors who have a product that they've, or a process or something that they want to protect is where you would spend most of your time, trying to court clients. Is that accurate? I mean, you mentioned, you work closely with them and you use them as kind of a funnel maybe to give them assistance, but is that where you spend most of your time trying to find new clients? Well,
I mean, my practice is split pretty close between trademark and patent law.
Okay.
So trademark law is for branding, and it's important to protect your brands, especially if you come up with new slogans or new divisions or new logos, et cetera. Again, intangible asset, the right to exclude others from using it. So that's really fun and exciting because trademarks and branding are omnipresent amongst the zeitgeist. So we constantly are driving around. We see logos all over the place, from our iPhones to our laptops to our watches to our clothing, to our vehicles. So that's exciting and fun. And then from the patent law standpoint, so a lot of times people think inventor and they picture, Beauty and the Beast, Belle's dad. He's all by himself in some little shed working on some contraption that makes a lot of bubbly noises, and then boom, there's some invention that makes bubbles and drives forward. But that's typically not where most inventions are coming out of. If you look at who are the largest patent filers in the state of Michigan, it's GM, Ford, Toyota, it's automotive, and Stryker. I think actually Stryker might be number 2 in the state. And Stryker makes, I don't want to say medical supplies, but medical devices, right?
Yep.
Anywhere from, I think they make MRI imaging machines to hospital beds, et cetera.
The actual hip replacement stuff too. They have a medical, they have both sides of that. Yep.
So what you have is a lot of very large, well-funded companies on the billion-dollar level or multi-million-dollar level, and they are constantly spending a lot of resources on research and development versus just selling and producing products. And so those companies, they have a large role, not only marketing and sales and awareness, but they also have to bridge or marry the gap between what's going out on the shelf and what's happening in their R&D facilities. And so they're the ones that are the most active in pursuing patents. And they'll have a process where you fill out an invention disclosure, you submit it to whatever department, their legal department that wants to, filter out what they like and what they don't like. And then it moves on to, they usually send it out to a patent lawyer to prepare an application, file it, and then they have stuff constantly on the move, right? Everything's like going month to month, year to year. And they have a budget planned out, et cetera. So those are the big ones. But for individuals, there's lots of resources out there. There's 100K ideas in Flint that can give you a portfolio for a very low amount of money that gives you some knowledge and information about where this idea would land in the market. And what I always try to emphasize with individuals that, patents are not cheap. So from start to finish, it might cost you $25,000. It might be anywhere from $15,000 to $30,000. It depends on what you're trying to invent. And that cost is spread out over time. But what's really important is that they realize that there's lots of different areas that need to be in sync if you're going to have success with this invention. So that includes, it may include marketing, it may include cost, it may include market penetration, it may include sales channels, right? And competitor analysis. It may include the team that you have built. And to be honest, those are the things that if you're seeking investments or you're seeking private equity or angel funding, they're going to be more concerned about that necessarily than whatever intellectual property you have. However, if you don't have the right IP, that may be a dead end for you.
Right.
So it's one aspect of a bunch of things that have to be in order. And so for an individual, the difference between IBM and that individual is essentially resources, right? If you only have $20,000 to spend to get your idea to market that you built in your garage, like Bell's dad did, then maybe patents isn't the right way to pursue it. Or maybe there's some more cost effective, like filing provisional patent applications. And you can contact myself. You can find me on our website on fosterswift.com and reach out, and we can provide some information to you. But people sometimes think like, hey, hand me a patent. If I offer you a patent for free and hand it to you today, which is impossible. But if I did, that doesn't come with a check for $1 million. And by the way, your phone doesn't start ringing off the hook with companies looking to license it or take it off your hands. There's other companies like inventtribe.com that was actually started by a local guy named David Fedowa, based out of Hazlitt. And he has a website where he coaches people on how to take their invention, prepare a sales sheet, and find companies to call and contact for unsolicited ideas, and maybe they're willing to license it. But it's often a lot longer and more tedious of a process than people realize. Right. Whereas like the large corporations or even the medium-sized corporations may have a process established, a budget and a plan to move that stuff forward. What's fun about Michigan State and what's also fun about working in Michigan and working with startups, which is what the interest is of these, a lot of interest in this show, is if they come out of MSU, they've already gone through a lot of the legwork, right, through the Research Foundation or through RISE, and they may access some of these smart zones like LEAP. Mm-hmm. And Bob and his crew are doing such a great job over there at LEAP, and they have access to to lots of different funding sources that will pay for things like, hey, here's $10,000 to help you build a website. Here's $5,000 to help you file for a patent. So it's literally no money out of the startup's pocket, and allows them to focus on what they are good at while feeling at least comfortable that their floor has been raised and they're not going to fall in some legal pitfalls that they weren't ready for.
Nice. So as we kind of wrap up here, what's your closing message to entrepreneurs and inventors and startups who are facing some of these decisions? I don't have a lot of cash flow, but I've got something that I'm really excited about. When do I reach out to someone? How do I find these grants or loans or whatever to help me get from where I am to where I need to get to?
I mean, the easiest thing to say in a vacuum is file early and often. So contact your patent attorney or go to the uspto.gov and read about what patents are, what trademarks are, and what their office does. There's so much information out there. And if you really are interested in moving forward with your business, and this isn't just some hobby, then it's important to educate yourself. And I think to stay educated on this topic is challenging, but there is a lot of information on the U.S. Patent Office website that provides guidance and information that is plainly understandable to some extent for an individual that doesn't have that legal background. And if you reach out to, or you go to fosterswift.com, we have a blog and a video series that happens on the second Wednesday of every month, and it covers a variety of topics, but they're all available through our website. And we have lots of lawyers that can help with startups, that are corporate lawyers that can help with corporate formation or with deal formation or even employment guidance and so on. And lawyers are really there. The important thing is to find a lawyer you trust. Right. If you're concerned about hiring a lawyer, call 2 or 3 different ones and go with the one that you feel like you can trust the most and ask for referrals. But, obviously I support Foster Swift and the people I work with are fantastic. They're really highly competent, highly skilled, highly experienced, and they like working with startups, individuals, and it's just a it's just one thing that you don't want to overlook as a brand new company is your legal and your accounting needs. And those are the things that can sometimes get you in trouble. For example, like here's an easy piece of advice. Don't start a website with your business and use pictures without permission. So there's easily affordable $100 photographs that are available for commercial purposes on Getty Images or whatever other resource you want, or take your own pictures, which are always free to use on your behalf.
Right.
But sometimes people grab a picture off the photo, copy and paste it because it's so easy, and next thing you know, they get a letter from a copyright troll that says you know pay us $18,000 to use this picture without permission. And I've dealt with several of those, and it's really important to take that down and really use images that you only have permission for. And honestly, if people were more educated about that, then that would happen a lot less.
Makes a lot of sense. A lot of great information here. We'll remind everyone, Mike, how people can get in touch with you to learn more.
Yeah, so people can find me on the Foster Swift website, www.fosterswift.com. And we have a lot of content and information there that's available for the public, especially if companies are interested in learning more or individuals. Anything from estate planning to litigation to probate and corporate formation, especially in the business and tax group.
Excellent. Well, we've been talking to intellectual property attorney, senior attorney from Foster, Swift, Collins & Smith, PC, Mr. Mikhail Murshak. Well, thank you so much for being back on the show, Mike. And I'd love to give a final shout out to all my loyal sponsors: Forsberg Real Estate, Wagner Financial, Triterra Environmental, Good Marketing, Keller Williams, Advantage and Team, Michigan Rise, and the attorneys at Foster Swift. These are fantastic people who are worth the call. And if you found this show as a one-off, I want to remind you to follow and subscribe to Michigan Reimagined on YouTube, Facebook, Apple Podcasts, Google Podcasts, Spotify, iHeartRadio, and pretty much anywhere you find your podcasts. This is Chris Buck signing off for Michigan Reimagined.